In breaking news recently, covered by the Human Rights Law Center, David McBride has been sentenced to almost 6 years jail for leaking documents to the ABC, which helped expose war crimes in Afghanistan. He is the first person to be imprisoned in relation to Australia's war crimes in Afghanistan. The whistleblower, not a war criminal. This is a dark day for our democracy and will have a grave, chilling effect on potential whistleblowers. Whistleblowers make Australia a better place by exposing human rights abuses, wrongdoing, and corruption. The people of Australia are in a disease state, it seems. Cases like McBride not only highlight the moral relativism that guides the Crown, what is not seen is that McBride is not an outlier. In fact, he is a signpost for how the courts are conducting themselves in many facets, if not how society sees itself. I would suggest that the central argument in McBride's case is not legislative at all. It's constitutional. It is common law, if not natural law. Specifically, the high beacon of all freedoms, that of freedom of speech. It may even be that it is worth considering McBride's defense as one involving the implied freedom of political communication outlined in Brown v. Tasmania, 2017 in the High Court of Australia, and many other similar cases, such as Clubb v. Edwards in 2019, McCloy v. New South Wales in 2015, and Lang v. Australian Broadcasting Corporation in 1997, that were all heard in the High Court of Australia. However, what is lost both notionally and in principle, Australia does have freedom of speech, but very few cases have brought this argument to the fore. In one such case, Tajur v. NSW in 2014, this was agitated briefly, but the High Court shut the argument down, and the defendant's lawyers didn't pursue it. Ostensibly, the High Court rolled out its usual trope that is steeped in redcoat history, that political communication is protected by the implied freedom, but speech is to be regulated by the states. In other words, the defendant must submit and obey to the all-powerful and all-knowing Crown. It would appear that no one wants to challenge this presumption, despite the fact that the Australian Constitution was founded on the principles of the US Constitution and its Bill of Rights. The fundamental difference being that framers of our Constitution took a very Millsian approach by protecting rights negatively, where freedoms are protected not on an individual level, but as a restraint on all lawmaking power. Despite this, in all practicality, our speech is very much regulated by the states, which is why we have state protections that are becoming tyrannical in their essence, protecting people by limiting speech under the guise of anti-discrimination. Regardless, it is clear that there is public outrage at the finding in McBride's case, yet so few are willing to look under the proverbial hood that is empowering the Crown to make such decisions. The fact is, we cannot have our cake and eat it too. Freedom is always limited by the allure of safety, and here McBride is being punished for our sins of not standing up for our common law rights and protections. If you'd like to contribute to help make these videos possible, consider making a donation at constitutionalawarenessaustralia.com.au.